everyone's coming for the next case. Okay. I think, Mr. Elliott, you still have your microphone on mute.
Yes, Your Honor. I thought I would try not to make any noise while.
Well, you're a good-looking guy, but we still want to hear what you have to say. All right, you ready to roll? Both sides ready?
Ready to go.
All right, let's do it.
May it please the court. My name is John Tasso. I represent Florida Gas. There's a cross appeal. I'd like to reserve 7 minutes for rebuttal.
I'll make an exception. I'll give you the 7.
Thank you, Your Honor. Back in 2000, Florida Gas obtained its first easement on Mr. Petrash's property. It installed a 30-inch pipeline. Mr. Petrash's property, it's undisputed, is primarily in a floodplain. It's comprised primarily of hardwood swamp, and it's been a wetland ever since Mr. Petrash purchased the property up until the present.
Well, doesn't that go to value? Isn't that like things that were argued to the jury? Why is that part of your facts on appeal? What do we do with that?
It'll tie in, Your Honor, directly to the cost to cure analysis for the damages on the verdict. In 2010, Florida Gas uses a quick take procedure to obtain a second easement. Florida Gas deposits the good faith value with the court. That money is dispersed to Mr. Petrash. And Florida Gas installs a 36-inch pipeline, and it does it in the very same corridor that the 30-inch pipeline had previously been installed. Florida Gas's pipeline, both pipelines are in the far western portion of Mr. Petrash's property. Mr. Petrash's property has been described by all the parties as a pot with a handle. The handle is what I'm going to talk about as Tract A. That's fronting MLK, State Road 574, approximately 230 feet. And then there's a 40-acre section in the back, which is Tract B, which is in the floodplain and is primarily a wetland. Now, this appeal is not your typical appeal relating to an eminent domain case. Florida Gas acquired the easements, it installs the pipeline, and then there's a valuation trial on the easements in 2019. Florida Gas is not disputing the values of the permanent and the temporary easements. Florida Gas has already paid for the temporary and permanent easements that it acquired in 2010. So what is this appeal about? There is a breach of contract claim. 5 years after the order of taking, Mr. Petrash files permissive counterclaims. How do we know they're permissive counterclaims? We know it because in his motion to amend, he says that the claims did not happen and they didn't accrue until after Florida Gas commenced construction. And it did the construction over a year after the order of taking hearing. And then in the counterclaim itself, in the breach of contract counterclaim that I'll talk about in a moment, on its face, it says that the counterclaim, it does not arise from the taking itself. It concerns actions that happened later.
The cleanup theory. Property wasn't put back together in the same usable condition. There was some flooding issues created that weren't cured by the repairs.
That is correct, Your Honor.
Okay.
That's the claim. So if we fast forward to the trial, what is this appeal about? It's very simple. What happens is the jury awards $493,780 for breach of contract. Under this court's decision in Benefield, and this is 352 Southern 2nd 892, you got a second DCA case right on point when you have property damage and the issue is the diminution in market value versus and the appropriate measure of damages. What you do is you look at the diminution in market value, and if you can fix the problem for less than the diminution in market value, that's the measure of damages. Based on this record, the only competent substantial evidence supports the cost to cure number in the amount of $239,142. Where am I getting that?
There was testimony to higher amounts, correct?
There is no testimony to higher amounts for the cost to cure, none.
But I'm sorry, the verdict form was not itemized. Is that correct? So we don't know how the jury got the numbers they actually got. What you say may be accurate, but what the other side, I'm sure, will point out, there's other evidence of other damages, but the verdict form is not itemized, which is a problem for us in reaching the conclusion that you say we should reach.
The verdict on the breach of contract damages is not itemized, but it couldn't have been itemized any further. The cases that are, and I'll talk about preservation issues to the extent they come up in rebuttal, but those involve situations where you have a non-economic damages that are part of the claim. This cost to cure of Tract A and Tract B, this is the $239,142. This is coming directly from Mr. Petrash's experts. That's the only competent substantial evidence. We asked the court to give an instruction under Benefield, a jury instruction, so that the jury, when it went back and it decided that verdict form, it would have a proper instruction on the law on Benefield, on cost to cure and market diminution. We asked for it. The court said, I'm not going to give it because I think it'll be confusing, and I'll deal with this issue on a motion for a new trial or remittitor. Petrash's counsel chimes in. He says he's not going to do he's not going to seek any damages that violate the Benefield principle, and that no instruction is necessary. What happens? We filed the motion for a new trial and a remittitor. Mr. Petrash files a response. The court denies it without a hearing. So we never have the analysis under Benefield on this record. So I want to talk about the possible approaches because I've got to meet this burden, and I'm going to do it, to show you that there's no competent substantial evidence to support anything higher than the $239,000. The first approach, and this is the one that is argued by Petrash's counsel in closing, he says, give me the cost of the reproduction cost of my canal system. Now, it's important for the court to understand the canal system. It runs all the way around the perimeter of Tract B. This is the pot. And so you have this canal system that supposedly, based on the evidence at trial, is rendered valueless because there is an obstruction, not on Mr. Petrash's property, but on a property that's owned by a Mr. Potter to the north of Mr. Petrash. Here's the problem with using the reproduction cost of the canal. There was no evidence below. When we can study this record until we're blue in the face, there's no evidence that awarding a new canal system was going to fix the problem, the drainage problem that Mr. Petrash was complaining about. It's two ships passing in the night. And then the second problem with the drainage canal approach, you don't have to look any further than Mr. Pearson's testimony. And I'll point the court to it. This is in the transcript at page 559. Mr. Pearson is Mr. Petrash's appraiser. He says he refuses to include any additional value due to the canal system. He said because it's baked right into the market value of the property. And so you have a situation here, and he says that if I awarded or told the jury that it should also award the reproduction cost on the canal, I would be double dipping. That's not my language. That's the language from Mr. Petrash's counsel. So you can't get to the $493,000 from the reproduction cost of the canal. There's no way to get there. And the other approach that is used, and this is the one to try to avoid the problem of how there's a limitation based on the cost to cure number, is, well, let's go to Mr. Petrash's testimony, where he talks about the percent of the property declined in value based on his claims about Florida Gas's failure to restore.
Yeah, but one of these issues could have been solved had Florida Gas requested an itemized verdict form concerning Tract A, Tract B, canal, everything. They didn't. And then when the plaintiff's attorney asked for $600-something thousand, Florida Gas never gave the jury a monetary alternative at all. Never objected to it either.
So on the verdict form issue, there's nothing that could have been inserted in the verdict form to have addressed the damages that aren't available under the law. If the Benefield instruction had been given, the jury would have been properly instructed on what it should award, and then it should award the number based on the cost to cure. We asked for that instruction; it wasn't given, But
if you're arguing that there was testimony in evidence of a fixed value of the cost to cure, the jury could have been asked that in an interrogatory. Please state the amount that was proven for the cost to cure. That wasn't requested.
Your Honor, there's no itemization in the verdict form, but we had asked the court to give an instruction.
I get it.
I don't
You keep-
see
you
that
keep
as an
pounding on
issue
the
in this
instruction.
appeal.
I'm talking about the verdict form itself, the most important piece of paper in a civil trial, in any trial. The most important piece of paper is the verdict form. You didn't ask for it.
We did not ask for itemizing of the breach of contract damages. We were relying on the court post-trial doing what it said it was going to do. The case law that we cite in our brief doesn't create a problem with the verdict form in a case like this. We're not in a situation where there's non-economic damages that are being sought, and where it therefore makes it impossible for the appellate court to understand the damages. That's not what's going on here. These are all economic damages. On the testimony from Mr. Petrash about percentage value reduction, what I'll do is I'll point the court to the KR decision. This is right on point. KR 155 Southern 3rd 507. You have an owner like Mr. Petrash that uses the words probably, maybe, and then gives a percent value reduction on his property. And the court says in KR, that's not competent substantial evidence. That's not good enough. Now on the, there's a few other issues I wanted to address briefly. There's a fee motion that is also pending. Mr. Petrash's counsel goes to great lengths in the brief to try to conflate the eminent domain valuation claims, which Florida Gas has not appealed, and the breach of contract damages claim, which Florida Gas has appealed. We would ask the court to carry the fee motion because there's a pending appeal in 2D19-1800 on the fee award from the trial court based on Mr. Petrash's claims. You have a situation here where if you have the Mr. Petrash in his counterclaims admitting that these claims relating to construction did not arise from the taking and that they did not accrue until construction, there's no way under that scenario that under Florida law, the breach of contract permissive counterclaim is an ancillary or a supplemental proceeding. I will save the remainder of my time for rebuttal.
Ready? Judge Vellante, I think your mic is muted.
How's that?
Now we're in business. Good morning. May it please the court. I'm Tom Elliott here with my partner who is socially distanced away in the other corner of the office, Shirley Faircloth. And we're pleased, along with co-counsel David Holloway, to represent Mr. Petrash in this appeal. There are not two disputes in this case. There was one eminent domain case. And a big part of what this is all about is trying to get this court to say, oh, well, if we're going to treat this other as separate and not give them a fee, which is mandated under the law. And I'm going to come back to the fee in a bit, but because I do want to touch on that. I do not plan, I'll reserve 2 minutes for rebuttal if there is anything on the cross appeal, but as stated earlier in the briefs, if the court affirms the main appeal, we will abandon the cross appeal. Because this has gone on for over 10 years, and Mr. Petrash would like it to come to an end. Now, as I think the questions have already focused on, the real issue in this appeal for the damage amount is there any basis in the record to support this verdict? And the answer is clearly yes. There are several bases, and I'll go through rather quickly what they are. Some of them, they're probably more than I've got listed. Restore the land was 239. The canal 419. That's greater than the amount of the verdict. Before this project and after the 2000 project, Florida Gas came back. They reseeded the land. Mr. Petrash was able to use it for grazing. Use the whole 40 acres in Tract B. It was usable land. That's not the case after the 2010 construction. It has turned it into a muddy bog. So that is one way to measure it. That's a fair way. Those are not duplicative. The land restored is separate from the canal functioning. Now, as far as the Benefield argument goes, and by the way, the complaint about the jury instruction, that's not part of the appeal. They didn't appeal saying give us a new trial for a new jury instruction. So that's really neither here nor there.
Well, there's no requirement that the court use an itemized verdict in a civil case anyway, correct?
There isn't, but I think the questions were very.
It would have been helpful in this case, obviously.
On target, absolutely. If they wanted to make these kind of arguments, they needed to have a verdict. And you can look at the verdict form for the first question. It is detailed itemized. So they could have had that here. They didn't ask for it.
Well, Mr. Alligan, it seems as if the argument by Mr. Tasso is that the Benefield factors support his motion for remitter.
I disagree.
Help me out with that.
Sure, Your Honor. The question is, you're not going to spend $419 to improve a piece of property if you're not correcting more than $419,000 in damage. That's essentially what it is. But that's because they want to rely and cherry pick the evidence that they say, oh, look, there's not that much value. It's just $239. That's only a part of the case. For example, Pearson, the expert you heard about earlier for the plaintiff, he valued Tract B at $1.14 million as having a land value before this. Mr. Petrus testified it probably lost half the value because of this, because he could use the property. And reasonable probability is the eminent domain standard. We've cited the Broward v. Patel case for that. They don't even discuss that case in their reply brief. I mean, probable is what we use all the time. More probable than not that this act caused this injury and so forth, whether it's in torts or in this situation. So saying it probably lost half the value is fine. That evidence was sufficient. If they didn't think it was sufficient, they needed to move to strike it. They never did that. We're in a jury trial.
But I have a question for you, just so I understand. If this was to be remitted, then that would bring into play your cross appeal, because then you'd want to have Tract A issues reevaluated.
Yes.
Because you have basically two triangle pieces of land bisected by this easement.
I'm not sure I don't know that they're bisected by the easement, but they're.
Well, Tract A is divided. Is affected by the easement.
Yes, yes, it is, Your Honor.
Okay.
Yes, and I'm going to get, because remember the verdict here is for Tracts A and B, for damage to both Tracts A and B.
But you didn't get the evidence in, and that's your problem on the cross appeal. The judge excluded all evidence, not just speculative evidence. So nobody could speak about Tract A from your behalf because it was limited by this pretrial in limine ruling by the judge, and it kept changing judges.
Well, we couldn't call it. We certainly couldn't call it severance damages. But Your Honor, let's talk about Tract A for a minute, because there's enough evidence in this record just on Tract A to more than support the verdict. Because Mr. Haynes, that's Florida Gas's appraiser, he testified that the value went from $5 a square foot to 0.92 to 92 cents a square foot. That's a $624,000 loss of value. Now, he wants to blame that on, oh, well, there's a sinkhole there. The jury went out and saw the property. The jury was entitled to reject that rationale and then find that, okay, why the reason the damages went down is because of what you, Florida Gas, did. So that's another reason. That's a third way you get to more than $493,000 in damages. Another way you get there is what we said in the brief. You've got Haynes valuing Tract B at $40 an acre. And then he's told, oh, it's wet. And so then he brings it down to $10 an acre, excuse me, $10,000 an acre. That's a $1.2 million drop. And, you know, they want to say, well, he didn't do a before and after value. Well, all the values, of course, are set in 2010, the date of the taking. But the reason he reduced his opinion on value is because of what Florida Gas did in 2011. And he's looking at it and saying it's wet in 2017. He walked the property. He was out and saw the property in 2009 before he did his appraisal at $40,000 an acre. So there's a fourth way right there to get to the damages. And so I can go on, but I think there's plenty of evidence here for the damages. they don't like some of the testimony. It was incumbent upon them to move to strike it. This is not a bench trial where you can get to the end and say, well, Judge, you can't do this, you can't look at this. As we pointed out in our brief at pages, I think it's 38 to 40 and 48, 49, when you let evidence come in and you don't object to it, it's part of the case and the jury can consider it. And Mr. Petrus's testimony was fine anyway, because there's nothing wrong with saying probably. Now, I want to touch briefly on the prejudgment interest point, because everybody here testified to 2010 as the taking date. Now, the judge said it at 2011 because that's when the damages occurred. Or I guess that was when the construction was and the damages resulted after that. The insurance cases that are cited are inapposite. Those are cases in which either you couldn't tell or the jury was told these are the costs to fix something today. Everybody here testified about 2010 costs on value and on repairs and on fixing the property.
Florida Gas considered its construction work complete as of February 2011. And the judge awarded interest starting March 1st. So yes, how could you not argue that the damages weren't fixed on that date? So that's when the claim arose.
Yes, yes, Your Honor. And let's talk about that for a moment, because the date and the claim, and this ties into the attorney's fees. 73.131(2), which is the appellate attorney's fee statute for eminent domain, says the petitioner shall pay fees in any case that the petitioner takes, in which the landowner is the appellee, and that's win or lose. We have detailed this in our motion for fees, and then they moved to consolidate, and we have a long response to the consolidation. And I appreciate that this panel may not have been the one that considered that. So I would urge the court to go back and look at our response to the consolidation, because it lays out why this is still an eminent domain case. I mean, Florida Gas promised to restore the property as an integral part of getting the property. It testified to that at the taking hearing to get the order of taking. The order of taking then incorporates the term sheet, which includes the promise to restore. This is one eminent domain case. These are damages that flow out of it. And that is clear. We cited the Mobile Gas and the Schick case in the order, which you can clearly see that in these type of after the fact things, the court is ordering eminent domain attorney's fees. And indeed, this court did the same thing in the M&C Associates case that we cite in the response to consolidation. That's at 682 Southern 2nd, 640. And what happened there was you had DOT had a settlement agreement, and part of that had the court reserve jurisdiction to assess any damage to the pool caused by construction. Damage to the pool, damage to the property. It's the same thing. There's an agreement there. There was an agreement here. So then at the end of the case, the DOT convinced the trial court to dismiss the case. This court reversed that and said, no, you're going forward. And you know what this court says in the last paragraph? It says, in this eminent domain proceeding, it is undisputed, DOT agreed. In other words, the repair is still part of the eminent domain proceeding. And it's also apparent that that's the case because we have attached, I believe, the docket sheet, and you can go back and look at the docket sheet in M&C Associates, and you will see that this court ordered appellate attorney's fees. So this is, I mean, to allow this argument to prevail, that there's no fee here because we've carved out this separate little piece, would be a great day for Florida Gas and all the other condemnors. It'd be a terrible day for Florida citizens who would never be able to get an attorney to represent them when the condemning authority doesn't do something that it has promised to do in terms of the taking. That's what I wanted to say. If there are any questions on the cross appeal, I'll be glad to try to answer them. Otherwise, I would ask that you affirm.
All right, I'll save you 2 minutes. Mr. Tasso, I think you asked for 7 minutes, correct?
Yes, please.
You got it.
I want to start initially with the issue about how this property became wetter. Mr. Elegant ties this into changes in the appraisals and how they were presented. The only expert hydrologist that testified at the trial, Mr. Bruce MacArthur, testified that the hydrology on this property didn't change after the construction. It's always been a wetland. It continued to be a wetland after. Tract B, the 40-acre tract, was floodplain before the taking. It was in the floodplain after. It's been you have wetland delineations for the property in the back. All of you have a hydrologist that comes in and offers that testimony. I want to talk about these other approaches. So I talked in my opening remarks about how you can't use the canal of reproduction costs. And I didn't hear any discussion about that. The reason you can't is there wasn't any evidence about how there needed to be a brand new canal. And then I also talked about the KR case and how a court said that if you have a probably maybe testimony from an owner, that's not enough. So what I want to focus in now are the alleged other facts that would support the verdict. We heard a moment ago that Mr. Chuck Haynes, Florida Gas's appraiser, offered testimony about the value of the tracts that could be used to support the jury's verdict. That's extremely misleading. Here's why. It's misleading because the date of take that Mr. Chuck Haynes testified to for all of his appraisals was March 17, 2010. And that is on page 164 of the transcript. The construction doesn't happen until after a year later. So to try to come in now and say that Mr. Haynes' appraisal testimony, when he has when all of his appraisals are before the construction ever started, to say that that could be competent substantial evidence to support the verdict is totally misleading, completely misleading. What I want to do is address the issue of the severance damages and whether if there was a potential remand, how Tract A would come into the picture. This is part of the problem with this case is when you have permissive construction counterclaims that are also tried at the same time as the easement valuation claims, it's easy to introduce confusion. And this is an example of it. The severance damages that are the subject matter of the cross appeal, those are not related to the construction. Those are related to the taking by Florida Gas back in 2010 and what effect that might have on the ability to develop Tract A commercially. Has nothing to do with the construction breach of contract counterclaim. So why am I making this point? I'm making this point because in the cross appeal, and we briefed this, there's no reason, it's not just that there were multiple trial judges, it's that P-Trash tried 3 different times to persuade the court that you could have severance damages based on Florida Gas's purported refusal to allow parking. And so, but what happened is you have the order of the court, the Judge Wolfender says that if you try to do parking in the future and Florida Gas doesn't allow it, come on in and get a claim for damages. So what happens is fast forward to trial. This is not a situation where Mr. P-Trash is shut down on introducing evidence of severance damages at trial. That's not what happens. What happens is the only evidence that's proffered is that because there's a second easement, that could somehow be a basis because the terms in the 2010 easement are different than the terms in the 2000 easement. And we can put them up on a board. We can say some of these provisions in 2010 are more restrictive than the ones in the 2000, that somehow that would be enough to support severance damages. That's wrong because that fails the Finkelstein case from the Supreme Court of Florida about how you actually have to introduce market evidence that would support that using comparable sales, that the property, the remainder portion of Tract A would be worth less because there was a second easement. There was no proffer of any evidence on that below. There's a reference on the P-Trash testimony about the probably maybe and the 50%. Florida Gas didn't sit on its hands at trial on that issue. I argued the directed verdict motion. The court goes back and looks at the directed verdict argument and then looks at the motion for a new trial. We take head on the competent substantial evidence. And I would also invite the court to look at the testimony from Mr. P-Trash. This is on page 335, because the only way you can get to above the 239 cost to cure is if you try to hang your hat on the probably maybe testimony. That's the only path. And you can't get there because of the KR case And then if you actually look at the questions that Mr. Petrash has asked, they don't support, because his expert has testified that you can restore a portion of, or you can restore tract B and you can restore the contours. The question that Petrash has asked that results in the probably maybe answer could never be competent substantial evidence to support the record or to support the any verdict amount above the cost to cure.
Down to a minute and a half.
So what do we want the court to do? We would respectfully ask the court to instruct the trial court to enter damages for $239,142. That's the cost to cure. Alternatively, we would respectfully ask that the court have the trial court do what it said it was going to do, but never did, which is apply Benefield to this case. And if you apply Benefield to the case and you look at the testimony from Mr. Petrash's own experts on the cost to cure, that's under Benefield, that's the only damages that are awardable.
What do you recommend on the track A dilemma?
On tract A, because there's now no proffer to support severance damages that would be adequate under the law, on tract A, there's no dispute on tract A on the breach of contract claim. The cost, Mr. R.B. Roberts testified about the cost to cure for tract A. Tract A is taken care of. This blockage to the outfall canal, that relates to tract B. So tract A is totally covered with R.B. Roberts' testimony about the cost to cure.
You've got about 10 seconds.
And then on the fee issue, again, we asked that the court carry it. There's no case law that would take a permissive counterclaim and would say that that's an eminent domain proceeding. It's not there, and we respectfully ask that the court.
All right, you finished just on time. Mr. Elegant, you've got 2 minutes.
Thank you, Your Honor. I did hear some ranging over into the cross appeal and the questions of value on tract A. And on that, I would say on tract A, we have Haynes' testimony, their own appraiser. And this is at pages 200 and 221 of the transcript, where he went from $5 a square foot to 92 cents a square foot. That's a $624,000 loss of value when you measure the square feet that are in the almost 4 acres there. So that on its own is more than enough. And it shows there would have been a good severance damage claim, but here it's enough for the jury to put it in as a loss caused by this construction. The only other thing I would say is I think I was accused of misleading the court or something to that effect. And the statement was made, all the appraisals were before the construction. I would take issue with that. All the appraisal dates that were used were before the construction. But Mr. Haynes did his updated appraisal where he dropped it from 40 to 10 an acre in 2017. So that appraisal was done after the wetness, and then he dates it back, as he should, to 2010 to measure the loss. So
can you address his argument? Could you just address briefly for 5 or 10 seconds the argument on tract A that there was no proffer? Was there an obligation to proffer severance damages on tract A?
Well, Your Honor, there was a proffer. That's in the record, and we've referred to that. So I don't think it's accurate to say what they're saying is you didn't make enough of a proffer. Well, if they didn't think it made enough of a proffer, they needed to come in and say something then. The proffer was the proffer. The court accepted it. Court wasn't going to let this issue go to the jury, so I think that was sufficient.
All right, and that's going to be the last word because you're actually out of time. Thank you, gentlemen. Great argument. We're going to have to take a short break to try and cure a technical problem. We'll be back in about 10 minutes, hopefully.